For generations, when identification was the evidence, there was no way to check it. A jury either believed a witness or they did not, and nothing in the courtroom could go behind the memory and test it. Then biological evidence arrived. It made a specific subset of those cases checkable for the very first time. This testing did not re-examine the memory. Memory cannot be re-examined. It worked by answering the underlying question independently. Was this the person or not? The Innocence Project recorded 375 DNA exonerations between 1989 and 2020. Of those 375 DNA exonerations, 69% involved eyewitness misidentification. For scale, the same cases record 43% involving misapplied forensic science, 29% involving false confessions, and 17% involving informants. Eyewitness misidentification is the largest single contributing factor in that set. These categories are not exclusive. A single case commonly carries more than one, meaning an identification rarely acted alone and never singularly caused a conviction. A DNA exoneration is not a random sample of wrongful convictions. It is a sample selected entirely by the survival of testable biological evidence. These cases skew heavily towards sexual assault, because that is where biological evidence is most often collected, preserved, and still testable years later. In homicide cases, DNA testing far more often returns an indeterminate result. Sexual assault cases are disproportionately the cases that turn on a stranger identification. Because of this, eyewitness identification is overrepresented in the DNA exoneration set by construction. That 69% of DNA exonerations is a true statement about a particular non-representative subset. It is not a rate of anything in the wider population of convictions. The check on this data is the National Registry of Exonerations, which records exonerations regardless of whether DNA was involved at all. Across that much broader set, mistaken witness identification appears in a markedly smaller share. Both figures are accurate, they answer different questions, and the difference between them is the selection effect, not a contradiction. A mistaken identification is not by itself proof that the convicted person was innocent. In these cases, it was usually just the largest of several contributing factors. In 2014, the National Research Council examined the identification procedure itself and made specific recommendations. First, blind administration of both photo arrays and live lineups. Taking away the administrator's knowledge of which face is the suspect permanently closes the unconscious cueing channel. Second, a standard instruction before the witness looks. Telling the witness the perpetrator may or may not be in the lineup removes the psychological pull to simply select the closest match. Third, the confidence statement. The committee recommended that law enforcement document the witness's level of confidence verbatim at the exact moment when they first identify a suspect. Confidence levels expressed at later times are subject to recall bias. This captures the raw certainty in writing before time or the weight of a courtroom can act on it. Finally, they recommended that the video recording of eyewitness identification procedures become standard practice. These recommendations were not a verdict on any person or an accusation of misconduct. They were procedural guardrails, adopted unevenly, designed to protect well-meaning people from the flaws of an ordinary process. There is an assumption that showing faces one at a time, instead of all at once, is the established cure for misidentification. That tidy answer is not the established one. The committee addressed sequential presentation directly, stating, "At this point, the answer is no." Using discriminability as a criterion, there is, as yet, not enough evidence for the advantage of one procedure over another. That question remains open. And the proven reforms did not arrive as one national rule. They were implemented state by state, some by statute, some by court decision, and some by police departments adopting them voluntarily. By February 2023, 27 states had adopted the core reforms. More have followed since. It is still not all of them. Structural change to the justice system relies on slow, fragmented administrative shifts. There are no tidy silver bullets. The clear through line of this entire record is that nothing in the systemic failure required anyone to lie. A witness who was genuinely uncertain became genuinely certain. An administrator who meant well cued them without knowing it. And a jury did the reasonable thing with the most persuasive evidence in the room. The error was manufactured by an ordinary process working exactly as designed. It stayed entirely invisible for as long as there was nothing outside that process able to check it. What actually changed is small and unglamorous: who runs the procedure, what the witness is told before they look, and whether anyone writes down how sure they were at the moment they first pointed. Capturing that initial confidence before anything can alter it is the whole record in a sentence.